this is the best thing going for you, is a Chapter 7. Chapter 7 is better than the Chapter 13. They would tell you to do a Chapter 13. Why? Because the Chapter 13, what does it do? It consolidates all your debts from the alleged creditors. All of your creditors are operating under what you call as debt equity. They want to take your equity, they want to steal your equity through debt. Keep this in mind. They want to steal your equity through debt. So when you sign your names to any one of these instruments, they're signing your name to the instrument as a debtor. So once they sign your name as a debtor to the instrument, that's where they're stealing your equity. That's why they call it debt equity. All right? You can go to what you call is Investopedia, INVESTOPEDIA.com, Investopedia.com. That's a financial website that you can go to. You can go to the browser bar and you type in debt equity, and you can get the definition of what it says in debt equity. And I try to go through these things and take it slow because, again, this is new to people. Debt equity, Investopedia.
Here's a summary from Investopedia. Shareholders' equity defined. In the case of a corporation, stockholders' equity and owner's equity mean the same thing. Shareholders' equity also includes retained earnings, which is the amount of profit left over that is saved or retained and used to pay dividends, reduce debt, or buy back shares of stock.
And they're not allowing you to do that. They're keeping you on this side. But when your instrument, any one of these instruments are creating equity or generating equity on the market, they're keeping you in debt to steal your equity. They're not telling, listen, what I'm giving you here tonight, there's no mortgage broker, no financial officer is going to tell you exactly what I'm telling you. Why? Because they're in the business of making commissions, so they're not going to tell you that. They may not even know that because they may be a victim of the same system that we are victim to. So again, each one of these instruments that's on the board, and there's of course much more than just this. This is just the common thing that most of us fall into, where again, there's a lot of equity being generated. Like for instance, the birth certificate. Again, this is the Dictionary of Finance Investment Terms. When you go into the Dictionary of Finance Investment Terms, one of the things that you will learn is when they start talking about certain instruments. Like for instance, let's look up the word certificate. I've been over this quite a few times, but I think it's very important that I go back over it again for those who are new and for those who have heard this in the past, for me to go and take my time and be slow with this. So I'm going to be looking up the word certificate, and you're going to notice in the word certificate, there's language there that you would wonder why it's there. Again, certificate, formal declaration that can be used to document a fact. And what they say here, such as a birth certificate. Now, why would a birth certificate be mentioned here in the Dictionary of Finance and Investment Terms? Why? That's the question. Why? We did not know that the birth certificate at the very bottom of the left-hand side is written on what they call is a banknote. All birth certificates are printed on what you call is a banknote. And those birth certificates are being traded on the market. All right, again, that's your equity. Because your name is written in capital letters, it can be lowercase, it doesn't matter, on that birth certificate. So if your name is written on that certificate, they're technically saying you are a certificate holder. This is what I was reading earlier, you was hearing earlier. You are considered to be a certificate holder because of the fact that your name is on that birth certificate. All right? What we need to do, and this is the jewels I'm going to be dropping here tonight to wake people up to these financial instruments. You have to do what you call as a Freedom of Information Act to the Department of Commerce. The Department of Commerce is where your birth certificate is being traded. It goes to the Department of Vital Statistics and then to the Department of Commerce. We need to start putting in Freedom of Information requests, requesting your birth certificate to the Department of Commerce. Why? Over 20 years ago, when I first seen someone who did request a birth certificate from the Department of Commerce, it was stamped, bank stamps all over the face of the birth certificate from different banks. Today, they call it bank medallions. So again, what are they doing? They're trading your birth as a certificate, and you are a certificate holder, just like in a mortgage. Yes, brother. Ali, there's the mic right there, brother, on the table right there. You see?
Can you write out how you would write out Freedom of Information Act? Because I wrote via Freedom of Information Act one time, and they said this is improper the way you wrote.
Well, technically,
the request.
That's a very good question. I'm gonna share this with you. What I have learned in a Freedom of Information request, each agency or department has a department that deals specifically with those requests. Usually when you go online on their site, they would have the Freedom of Information form. They have what you call is a disclosure officer. That's technically who that goes to. Each department has that. So that's a very good question, because a lot of people do not know how to fill out a proper Freedom of Information request. So if you was to go to the Department of Commerce and look under Freedom of Information requests, normally they would have a template that would give you the form that you need. And the only thing you need to do is to insert your information proper and send that off certified return receipt, so you can hold somebody accountable, whoever received that. But you would get back the information. You just want, again, a copy of the birth certificate, all right, from the Department of Commerce. See, people is not aware of that. I think a lot of people need to be aware, and if they are, then they should have been applying for that, so they can show people exactly what's going on, all right? But my whole thing is this. It's not so much just getting a copy of the birth certificate from the Department of Commerce, but it's also the birth certificate, like any other of these instruments, have what you call is serial numbers. There's serial numbers on these instruments, all right? So why I'm making mention of the serial numbers? Because each one of those serial numbers is associated with this concept, which I've been talking about for a long time, the Q-sub number, all right? Because when you get the Q-sub number on any one of these instruments, it's gonna show you well, you would have to go further into research, like for instance, Standard & Poor's, Fidelity, and any other website that where you can take the Q-sub number, put it into that site, browse around, you can be able to see the instrument like the bond, all right? That's basically what I have done. Like some years ago, someone had a mortgage. We took the Q-sub number for the mortgage. We put it into Fidelity. I seen his mortgage bond. This is unheard of. When he called the Fidelity broker, he told the broker he'd like to be able to purchase a bond. I have the Q-sub number. Once he told the Fidelity broker that, the broker was amazed. He said, how do you know about this bond? He didn't say what it was. So I think it's very important that I make it clear to y'all, when you do get the Q-sub numbers on these instruments, do not make them aware that you know what it is. Just be on the phone and say, listen, I'd like to purchase some bonds. I got some Q-sub numbers. Make it simple. Don't get into saying, oh, this is my mortgage or my student loan. I know there's a bond on it. Don't get into it with them like that. Because most of us would do that and ruin it for everybody. All right? So when you do get the Q-sub number, you need to contact the Fidelity broker concerning the information you want to be able to purchase the bond. So you can purchase the bond on any one of these instruments. All right? If you have a student loan, you can purchase the bond. Once you purchase the bond on any one of these instruments, the show is over. The show is over, yes.
So the Freedom of Information Act could be for any one of those
Yes,
instruments there,
because
not just the birth certificate.
That's true, because basically, depending on what agency, most likely the birth, death, and marriage all fall within the county. You know, like if you got a certain municipality, right, You can get your marriage license there, you can get your death certificate there, you can get your birth certificate there. That would be the same place that you would do your freedom of information. All right, basically these three right here. All right, that happens within the municipality. All right, each one of these have their own agencies. You see what I'm saying? So that's a very good question. All right, that's why I always entertain questions, because questions invoke my thought to give you more information that you need concerning this matter. All right, but the main factor is you want to get this. This belongs to you. The equity, not the debt. The debt is what they got you into. All right? They can gentrify you through accounting fraud is to put debt around you. All right? And then the first thing we're talking about to the debt is to do what? Discharge. But we don't want to discharge no debt. The issue is you don't want to separate yourself from your obligation. Because again, the first place what I've learned about a discharge is through bankruptcy court. Bankruptcy court, under Chapter 7, is the discharge. And this is what you need to know. Again, true information. I'm going to tell you why Chapter 7 is more important than any other chapters when it comes to the discharge. When you go to what you call is 11 USC 5, Section 524. I'm going to read it. I'm going to read it. So you will know. Because one thing that you'll know about me, as Kemitu, I always show you the sources of information. I don't just be up here articulating information and just putting it on the board off the top of my head. No, I actually give you the source of where the information is coming from. So listen to this. Check this out. 11 USC Section 524. All right, sometimes it speaks out, sometimes it don't, but it's cool because I can read it out for you. Listen to what it says. All right, I'm showing this to the camera up close so you can see. You can see this. 11 USC Section 524. 11 USC Section 524. And let me read what it says. A discharge in a case under this title, what it says, voids any judgment. Listen to me carefully, because we wind up getting judgments. I don't care if the judgment is an auto loan, electric bill, credit card, student loan, mortgage with the note. You can get a judgment against you from any one of these debt instruments. So now you have a judgment on you. Once you have a judgment on you, matter of fact, historically speaking, a debtor back in England in the 1800s was considered to be a criminal. Do you hear what I'm saying? A debtor back in the 1800s during England, if you was a debtor, you was considered to be a criminal. Today, you're still being classified as a criminal if you were a debtor, but they don't push it on you as what they did in England. Because what they actually did was they will put you in prison in England. But I'm going to tell you something. Once you sign any one of these instruments, or these instruments was attached to you, right? You automatically becomes a debtor. Let me read something to you. Let me finish reading this first, and I got something else to read to you. A discharge in a case under this title voids any judgment at any time obtained to the extent that such judgment is determination of the person's liability of the debtor with respect to any debt discharged. You see? So it's very important that a Chapter 7 can actually void out a judgment. So what I'm saying here, and if you're paying close attention, if anyone out there who have done a Chapter 7 and got a discharge, what you're supposed to do is get a certified copy of that discharge, and you're supposed to get a certified copy of that judgment, and you're supposed to do what you call is an entry. All right? Certain states got different names for it. Like in Ohio, they call it journal entry. In New York, they call it notice of entry. So each state has their own name of entering that discharge on top of the judgment and file it into the clerk of the county where the discharge, the judgment has been filed. So you have to do that. You have to do that. Why? Because every time you bring a case, my brother, because you didn't get a judgment yet against you. Right, brother? Correct. So listen to me carefully. Once they achieve that, and anytime you try to bring an argument in court, the reason why they ignore it is because of the judgment. If you got a judgment standing over your head, they're saying that you're in dishonor. They're not going to tell you that. So whatever you put in there, they're going to ignore it. The lawyers is going to keep talking about the judgment. They're going to keep talking about the judgment, and the judge is going to keep ruling in their favor. All right, and that's going to be a problem. What one has to do is put in a motion to vacate that judgment. You have to vacate that judgment. All right, and you cannot go to federal court to vacate a judgment in state court because they're going to hit you with the Rucker-Feldman doctrine. I'm going to say it again. You cannot go to federal court to vacate a state judgment. They're going to hit you with the Rucker-Feldman doctrine. All right? And it's like 4 elements that would show this federal court that you fail in trying to overcome a judgment. They're going to break it down in elements. 4 elements under a Rucker-Feldman doctrine. You can look up the Rucker-Feldman doctrine, and everybody should look that up. Look up the Rucker-Feldman doctrine. Look up the Rucker-Feldman doctrine. Let me see. Show you what's going on.
You need some more big time.
No, I'm cool, brother. I appreciate you. I can use some water though, brother Ali. Because you know me, I'm going to put this word out here. I'm coming, brother. Let me just put this down here. The Rucker-Feldman doctrine. Rucker-Feldman. Doctrine. Very important to see that. Thank you, brother. Appreciate you, brother. Appreciate you. Please look that up. Rucker-Feldman doctrine. Don't take my word for anything. Look it up. Just don't be lazy. Look up the Rucker-Feldman doctrine, which means if you got a judgment pending against you in state court, I don't care if it's a credit card judgment, a mortgage judgment, or auto loan judgment, you cannot take it to federal court to try to overthrow that judgment. They're going to hit you, those attorneys is going to hit you with the Rucker-Feldman doctrine. There's tons of cases on the Rucker-Feldman doctrine. And so if you look that up, you're going to see exactly what I'm saying. So the only way you're going to be able to eliminate that judgment that's against you, you must file a pleading within that same jurisdiction, because they're going to say it's the judge who entered the judgment, so no other judge from any other jurisdiction is going to eliminate that judgment, only the judge who entered that judgment. The only way you're going to be able to eliminate that judgment, if the court do not acknowledge to remove that judgment, is to do a Chapter 7. Because I read 11 Usc Section 524 that says that a discharge voids any judgment. But see, the problem is this: even though we may get a Chapter 7, we did half the process. We did half the process. You said, what do you mean by you did half the process? Because we did not get a certified copy of the discharge, and we didn't get a certified copy of the judgment. You're putting those two together, and you want to enter that on the record at the clerk's office where the judgment is filed against you, at the judgment section. You want to file that in there. But you got to send the bank or the other parties who had obtained that judgment against you, you must send them notice that you're vacating the judgment against you. Very important. Yes, Brother Ali.
You got a sister over here that wants to know, how do we get the equity from a co-op?
From a co-op?
Yeah.
Excellent question. Excellent question. First of all, when it comes to co-ops, co-ops is different from having a house. They're robbing our people big time in co-ops. Co-ops is not really something to have because they're treating you like a tenant. They give you a proprietary lease and they would give you shares as, like you would say, ownership. What you're supposed to do, technically, which most people don't know to do this, if you have a proprietary lease, you're supposed to go and file it at the county clerk's office, the land records, when you have a co-op. But what you're supposed to do, let me give you some signs and show you how you can get your equity out of that, just besides what they're talking about as far as shares, because the shares is not really where the equity lies the most that you want to get out of it. Where it's at is you have to get the title deed of that complex. Remember, you are just a unit within that complex. You have a share within that complex. You have a proprietary lease within that complex. So what you have to do is get your proprietary lease, and you have to get the title deed of that complex, put those two together and file it in the clerk's office. See, the lawyers is not gonna tell you the information I'm giving you. All right? They're gonna index that. They're gonna index that. What happens is the title, right, to the property, there is a serial number or a title number. That's what I should have had up here also. And thank you for that question, because the title can be to a car, can be to a co-op, it could be to a house, townhouse, whatever. The title is insured. They got a bond or surety on the title. And there's some serial numbers that's on that title. And you can get, again, the QSUP number on that serial that's gonna show you where the equity really lies at. So that's a very good question. So that's the only process that you can go by, is getting the serial number from the title. But you gotta go to the land records from wherever county that you're located and pull the title on that complex. If you're living in a co-op, you gotta pull the title on that complex, all right? And you have to take your proprietary lease and attach that to that title, and then you file it into the clerk's office, all right? Because now you're under what you call as adverse possession. You need to look at that statute. Every state has an adverse possession statute. Every state has it. New York's adverse possession statute is 10 years. Other places like Connecticut is like what, I think 25 years. Each state is different, like in Maryland, every state is different when it comes to adverse possession. Because once you begin to start purchasing those shares and you went into a proprietary lease, that was adverse possession. But if you want to actually get the equity, not from the shares, that's something totally different from the title. But in order for you to qualify in getting that, you have to take your proprietary lease and attach it to the title to that complex and file it into the land records. And then you have to get the title information with the serial numbers on it. And then after that, we can get the QSUP number and we can find the bond on that property. And it'd be dangerous to that landowner, because guess what? If you get the bond to that property, that means you can never be put out of that co-op. Because they're treating the proprietary lease as though you are a tenant. All right, so I'm giving you some powerful information here tonight that you ain't gonna get from no lawyer. You know what I'm saying? No accountant, no bookkeeper, none of them out there is gonna be dropping the jewels that I'm dropping here tonight. All right, so again, this is about awakening the mind to financial instruments. All right, and I have to show you the due process of what you gotta go through. I can't show you everything here. You're gonna have to contact me in order to do other processes, because I'm not gonna put too much information out there, because one thing that I've learned is that when I put a lot of information out there, peace beloved, shalom alaikum. The issue is a lot of us get very reckless. We get very reckless and take information and go out there and start getting wrecked and gonna ruin for everybody. So I'm giving you where you should start first. If you're asking me about how to get the equity in reference to your co-op, you have to attach, again, your proprietary lease. For all those who got a co-op, you get your proprietary lease. I don't care how far back it go. And be careful with your proprietary lease. Because your proprietary lease, if it goes back 10 years, 20 years, I'm giving you hypotheticals, you keep on to that proprietary lease, because that proprietary lease is associated with your shares. What some of these companies do, I'm coming over. What some of these companies do, they give you another proprietary lease to supersede, right, your proprietary lease that goes back 10 to 20 years. So be careful, because they try to reconstruct the proprietary lease to try to disenfranchise you of your equity. So it's very important to be aware of that. So if there's any new leases coming up, don't sign it. You stick with your old proprietary lease that goes with your shares. They go together. Yes?
You got a more here said that they were never given a proprietary lease.
I'm aware of that also. And they got a problem. What they need to do is write a letter to management and say you need your proprietary lease. Very important. You got to write a letter, send certified return receipt to management concerning your proprietary lease. I'm aware of that also, because I have some folks who came to me in the past that they didn't have their proprietary lease. So that was an issue. And matter of fact, when you read the bylaws that they give you in reference to a co-op, it mentions the proprietary lease in them articles. So how in the hell you can be in a co-op and have shares or paying quote-unquote rent and don't have a proprietary lease? So you're gonna have to write a letter, certified term receipt, requesting that according to the bylaws. Get the bylaws now. Get the bylaws, because certain articles under the bylaws specifically talks about the proprietary lease. So you can always reference the bylaws when you do write your letter. All right, just don't write a letter and say, I didn't give a proprietary lease. No, pursuant to the bylaws, Article 8 or Article 9 or whatever the article it falls up under concerning the proprietary lease, that's what you quote. All right, and even make a copy of it with your letter, certified term receipt. They gotta comply under co-op law. Co-op law, there's a law for co-op, all right? And the state protects shareholders. So if they don't do that or comply, you can always file a complaint to a higher authority, and they would have to give you that proprietary lease. Yes, question?
Would you motion to vacate before or after the claim starts? Like, so if
You can, that's a very good question again. You can file a motion to vacate the action and then suspend it.
The
Yes,
action.
yes, you can do it now, presently. So not only that, you can do a counterclaim, but you can also do a motion to vacate it, to summons a complaint. But you gotta do it based on affirmative defenses. If you got something concrete, like for instance, let me give you an example. Say for instance, the company who got the mortgage, allegedly, assuming the mortgage, they may not even exist. So what I do for those who are listening, right, and this specifically happened with another sister, Morris sister who I'm helping, the company that she was dealing with was an Inc. back in 2010. But then what happened was, in 2016, they dissolved it. No, the state taxation and finance department dissolved their corporation for not paying their corporate tax. All right, that's what happened. Then they decide to go and put that company under an LLC. We went to the State Department, looked up that company, and found out that that company does not have corporate, just stands as an LLC. So we got back the certificate saying that they're not an LLC. So when we went to sue them, we made sure that we served the Secretary of State. Why? Because the Secretary of State would give them a fine for operating business that's not in certificate of standing or certificate of status. So you can do that. So those companies that you're dealing with, brother, you need to do research to find out, are they incorporated? All right? Some of them got robo-signers, like vice presidents and documentation managers. They got robo-signers in reference to notaries. If you pay attention to the notaries when it comes to the assignment of mortgage, a lot of those notaries are robo-signers, all right? And you can always, and wherever they state that they're saying that they're the notary from, that's the state that you check to find out, are they bona fide within the state of whatever it is, or Commonwealth, to see if they're notaries. If not, you want to be able to file a complaint against them. So it's very important to know this information. A lot of us are not aware of what's going on. This is the kind of work that I dig in like a Trojan horse on these folks, because they are killing us out here economically because we have no knowledge of what's going on. So these questions to me are very important, that you shoot me these questions, because I can answer your questions confidently and give you sources of references of information, all right, to help you. Any other question? Did I answer the sister's question in reference to the co-op?
If you can put your number up there,
Yes.
somewhere to the top.
All right, I'll put it. I'll definitely gonna put it.
All right.
I'm definitely gonna put it. Providing that you give me $1 donation for the Cash App for Ali. Very important, because people need to show support. Like I'm showing support here, you ain't gonna go to no law firm, sit down with no lawyer, and get the information that I'm dropping here tonight. None. Like for instance, let me give you an example. Let's go to 28 USC Section 454. Because a lot of us is running our stuff into the courts, and we are catching hell with these judges. I call them judicial lawyers, because that's what they are. Let me show you what's going on. Hold on. 28 USC Section 454.
According to Cornell Legal Information Institute, Cornell University, 28 U.S. Code Section 454, practice of law by justices and judges. Any justice or judge appointed under the authority of the United States who engages in the practice of law is guilty of a high misdemeanor.
You see that? Do you hear what they just said? Sometimes I gotta read it out, sometimes they talk it out. So now you know that any judge, magistrate, officer who's practicing law on the bench is a high misdemeanor. Did you hear what I'm saying, y'all?
Yes.
Wake up, y'all, and hear what Kemitu dropping, because nobody out there dropping it like I'm dropping it. So you better pile on in and show some support. All right? Show some support. The Cash App is the $ Ali Productions. The $ Ali Productions is the Cash App where you can show some love for the support of what I'm dropping here tonight. Because again, an attorney wants $100 an hour. It depends on the attorney. Some of them want $200 to $300 an hour just for consultation. I'm not giving you no consultation. I don't give you legal advice. I give you legal insight. Legal insight is better than an advice. So you just got some insight about 28 USC Section 454. It's a high misdemeanor if any judge or magistrate practice law from the bench, and this is what they do as common law. So what you need to do, again, is take the name of the judge and go to the bar of that state, be it that state or Commonwealth, put the judge's name in the Bar Association website, and you're going to see that that judge or that magistrate is coming up as a lawyer. He did not vacate or voke their bar license. They did not do that. So if they have not done that, and they have taken an oath to the Constitution for the United States and of the state, then what happens is they still practicing law from the bench. And 9 to the 10, when you're standing there in the courtroom in propria persona, what happens is that you'll find the judge helping more the lawyer than helping you. All right? What is he doing? Practicing law from the bench, which is a high misdemeanor. That's under 28 USC Section 454. Now, we're going to go to another section, which is 28 USC Section 455, Section 4. We're going to go there. I'm going to show you what I'm talking about. 28 USC Section 455. They call it disqualification of justice, judge, or magistrate. The same 3 titles that's in Section 454, who's practicing law from the bench, those are the ones who will be disqualified. See, we don't know this information. We don't know this information. If you got a case, my brother, right now, listen to me carefully. If y'all got cases right now, for those out there listening all over the country, if you got a case right now, I don't care if you got a criminal case or a civil case, take the name of that magistrate, that judge, or that justice, go to the Bar Association within the state that you are domiciled at, not in, at, all right, because it's adverse, so that's why it's at, not in. Because when you say you in, the preposition in means you are giving them jurisdiction. But when you say at, all right, that means you in adverse possession of that justice, judge, or magistrate. All right, so we got to watch our prepositions. All right, so when you take the name of that magistrate, that judge, or that justice, and go to the Bar Association of that state and put that particular entity or title within that Bar Association, the name of that particular judge, magistrate, or justice, you will see that they are lawyers, that they are attorneys, all right? And then he cannot preside over your case because that is a prejudice. He's automatically disqualify himself if he's sitting on the bench claiming him to be a magistrate, judge, or justice, and he still have his bar card. And listen to what it says right here. Any justice, judge, or magistrate, judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Let's go to Section 4. This is what Section 4 says. He knows that he individually or as a what? Fiduciary. All judges, magistrates, and justices are all fiduciaries when they sit on the bench. So when I do hear some of our Moorish brothers and sisters talking about, oh, give the judge a 56, which, you know, a notice of fiduciary, I said, no, you don't have to hit him with a 56. He's already a fiduciary. Because I already told you what the statute was before, prior to that, which they didn't even realize that it's associated to him being a fiduciary. That's the reason why you're supposed to give the judge who's going to reside over your case a W-9 form. Do you hear me, y'all? Because it's an internal revenue issue. I'm the only one out there that's dropping it to tell you that the criminal case and the civil case is all internal revenue proceeding. And if you want to shut them down, go to the IRS on them. Because they're collecting fees, dues, surcharges, and they're not reporting it. If you know what, and same thing over here with these instruments, these financial instruments that you have to have the waking of the mind. These same instruments, if you want to deal with these instruments, as far as notes is concerned, because the mortgage have a note, of course the note is a note, the student loan has a note, the credit card has a note, the auto loan has a note, all right? These have notes. Where do you go to see what's going on? Let me show you what's going on. Let me show you what I'm talking about, all right? Because I'm really sick and tired of misinformation that's being put out there, right? Let me finish doing this first. Let me go to section 4, because I did talk about the judge being a fiduciary. Let me go back to that first, and then close out and go to some other section you need to hear. He knows that he individually or as a fiduciary or his spouse or minor child residing in his household has a fiduciary interest in the subject matter in controversy of a party or in the party to the proceeding or any other interest that could be substantially affected to the outcome of the proceeding. So does he have a fiduciary interest in the case? Yes, he does. Yes, he does. A matter of fact, about 10, possibly further than that, years ago, they had what you call is the Q-sub number on a case or cases. It was called Chris. Let me show you what I'm talking about. All these courts have it, state and federal. Chris. I don't know if you heard of this. All courts have this. That's why you see me have this here. Courts, indexes, and dockets in all counties. Exactly. Very important that you get this, y'all. I taught this 10 years ago. I even pull up the document and they had the Q-sub number to the docket number. I taught this 10 years ago. But of course, I got to go back over this stuff because a whole lot of us came in who may not be aware of this, so I have to put this information out on the board. It's called CRIS, Court Registry Investment Systems. All right? This is where they take your money. When you pay the docket fee, or whatever fees you pay to the court, they invest that money. They take your money and invest it. All right? I'm going to show you some fly stuff tonight. Y'all going to love me. Because what I'm dropping here tonight, you ain't going to get this from nobody. Because nobody is putting this raw information out there. All right? I'm going to be buck wild, like a rock rattler on LSD tonight. You're going to see what I'm talking about. So I'm going to be rough on y'all tonight because y'all need to see this because these devils are wicked. All right? They are wicked. And we need to have this knowledge, but it needs to be executed properly. There's a certain procedure. There's a certain performance. We just don't go out there and just get wrecked. Noble Juali made it very clear back in his time because Noble Juali was catching hell back in his time. Because remember, and Noble Juali was close to the Negro state of mind back then than we are today. Because he was the one who said, I can't wake all your Moors up at one time. Why? Because you may wreck something. And that's what you're doing today. So things have to be done in decency and order. All right? Yes, my beloved brother. That's some more information. I got some serious information. I got time here, 8:33.
So
I got some jewels to drop on you.
if you either file a claim or a counterclaim, how do you fill out, I think it's a document you can fill out where you don't have to pay?
Yeah, it's a waiver of the fee.
Yeah.
But let me tell you something, brother. They got funds. Even when you waiver that fee because of your impoverished status, as they call it, they got funds to pay for that, regardless if you waive the fee or not. You get what I'm saying?
Yeah, I get it.
Because anything you pay will really be a surplus.
Correct.
Because they're getting, Amor brought this to my attention 15 years ago, and I was staggered. Let me tell you what the Moore said. He was showing me, never forget this Moore, because we got some very prominent Moors out there, and a lot of us don't know about these Moors. And these are the Moors I'm in contact with, because they be dropping jewels on me like I be dropping jewels on them. This Moor told me that any case that comes before a judge, all those cases are already prepaid in finance. They have to set up a certain amount of cases. They have to do what you call, is like an inventory of how many cases that they was listening to that year. And even if they put in their budget, those cases probably went over their budget. But what the Moore had told me, and he showed me, blew my mind, was that, say for instance, the courts have a budget to listen to 1,000 cases. And say for instance, 50 cases was over 1,000. Technically, those cases, the 50 cases, should have not been heard, because the budget was only for 1,000. Because those courts, management, send up a budget to get funding for those cases. So any case, any money that we pay out of our pocket, that's surplus. A lot of us don't know that. That's surplus. I do a lot of studies with the court system. And another thing too that we need to be aware, I'm gonna drop some jewels here tonight. It's gonna be hot like a firecracker, like 4th of July in here. Check this out. Say for instance, you dealing with a landlord and tenant case, and you got to go to landlord and tenant court. You need to find out the deed entitled to that landlord and tenant court building. Once you take control, because see, they want to put you out of your house, but we ain't putting them out of their house. So what I'm saying is, we need to start looking up the title of that property where housing court is at, all right, and take control of that. You'll be surprised who's the management over that housing court. You can look those things up through Dun & Bradstreet, through Manta.com. There's various companies out there that you can look and find out what's the name of what that building falls up under. All right, I remember one time I did some research on some clerk court, some court. It was set up as an LLC. It was set up as an LLC. Up in the Bronx, the family court is owned by the Bar Association and Family Court. Bar Association, the Bronx Bar Association owns Family Court up in the Bronx. Dr. Shirley Moore revealed that the family court in Los Angeles, California is owned by the judges. And the monies that's coming in is going into their slush fund. She showed that. I put people onto her 10 years ago. So I got to restate what been jumping off back then today, because ain't nothing have changed. So nothing have changed. So what I'm saying is that they're attacking our homes and our lands. We need to begin to start attacking their homes and their lands. We need to start looking up these judges to see where they live and start putting liens on their property, because they got a fiduciary interest on you. That means you have a claim on them. All right? This is what we should be doing. The hell with them devils. You see what I'm saying? So that's why I need some support, because they may come after me. You see what I'm saying? Because they don't expect this information coming out of our mouths. For all they're concerned, we Negroes, we ignorant. We don't know what the hell is going on. So even if they catch this on YouTube, they're going to be saying, damn, that Negro is dangerous. Who knows? They may even put me in Trump's mouth. Trump may start talking some negative about me. What was going on, Ali? Oh, true. Well, Ali was bringing something to my attention, And I think it's very important that we start creating our own credit unions. The Nation of Islam had the Million Man March twice, and I'm really disappointed because Farrakhan was in a position to have 1 million men pull their resources together to open up our own credit union. We can pull all our monies out of them goddamn banks who's doing us with the credit cards, the mortgages, the student loans. So we have to economically take control. All right? The hell with a goddamn politician. Because when you vote their asses in, they're going to do what Mr. Charlie does. All right? And get paid to keep you in the conditions that you in. But if Farrakhan would have had 1 million men back in 1995 and set up a credit union across this country, we wouldn't have to worry about banks collapsing. We wouldn't even have to worry about that. Shukran. We wouldn't have to worry about that. He had another chance in 2015 in October. Didn't do it. But he did came up and said, oh, we have a blueprint. Brother, 20 years ago you should have had that. Can you imagine if we would have had credit unions all over this country for a solid 20 years, pulling our monies out from the banks? Shukran, King. Can you imagine if that would have happened? Do you know what would have happened? If you would have thought that it was talking about the housing bubble, with the housing crisis, with the subprime markets, right? We would have definitely subprimed them, which means we would have subjected them because all of our brothers and sisters would have had our own credit union and we would have pulled our resources together. Did you know that Christian churches have credit unions across this country and they're building up senior citizen housing? I've seen it. I've been in the meetings. Christian churches have credit unions. They got their own credit union. Because the credit union is not for profit. So you don't have to be under certain banks and regulations and taxation. So what I'm saying here, we need to start our own credit union so our brothers and sisters can finance our own development. Because right now, we are being economically gentrified with accounting fraud. All right? One brother told me today that they did what you call is a charge-off, which is a write-off. Same damn thing. I had to show him, brother, don't let them devils fool you. I'm into linguistics, all right? A charge-off and a write-off, the same damn thing. Because at the end of the day, what the lender is supposed to do is supposed to write off that debt within that same taxable year. That's within the code, all right? I'm only telling you what's in the code, all right? Within that same taxable year, if you are delinquent, as they're claiming, and you can, technically, you ain't delinquent. Because again, I already told you, see, they're looking at this as delinquency. But if you got equity, you can never be delinquent. If you got a mortgage, or student loan, or car loan, or credit card, you can never be delinquent. Why? Because once we get the QSUP number on that serial number, you will find out that they're generating income and selling it to investors. So how could you be delinquent? And even if they do write it off as a delinquent loan to the IRS and give you what you call as a 1099A or a 1099C, that is tax fraud. That's misrepresentation and tax fraud. And we can get them with 2 different types of forms, depending on what corporate status they are in. Do you hear me what I'm saying? I'm dropping information that nobody is dropping. You can hit them with a 13909 form. What is a 13909 form? A 13909 form is a form that anytime a credit union, right, would give you a student loan or credit card loan or auto loan and say that you're delinquent, you didn't know that once you do a securitization on any one of those instruments, you'll find out that they sold that to a bank, making money on it. So what you have to do is file a 13909 against that credit union, and you would have the securitization audit showing where the money's being generated at. Do you hear what I'm saying? That's for a non-for-profit. The 13909 form is for the non-for-profits, like the credit unions, all right, who's out there jacking us up, all right, in the courtrooms with these corrupt judges, all right? That's the 13909. Nobody ever heard of that before, all right? But you most likely heard the 3949A. The 3949A is for those corporations or companies that are making profit. all right? And if they're committing tax fraud, that's the form. Matter of fact, that's like the whistleblower. That's the whistleblower form. Matter of fact, the IRS will pay you just for making that complaint, showing it. But usually what I do is to get these bastards, right, these corporate bastards, right, and banksters, you gotta do a securitization audit. You gotta do a securitization audit. I have contact with somebody who does that. They do it on the mortgage, student loan, credit cards, and auto loans. All right? He doesn't do it on the other ones. Well, this is what he used to do, but he don't do it no more because they came after him. He used to do it on court cases. I got the document. I could do a PowerPoint presentation and show you where the judge's name, the case, the amount of money, the courtroom. Oh, yes. Yes. But they kind of put the heat on him, so he kind of backed away from that. All right? So he just does credit cards, auto loans, student loans, and mortgages. That's what he does. All right? But I'm bold. Even though he doesn't do it no more, we can still take the index or the docket number, get the QSUP number on it, because again, I told you, it's all under the court registry investment systems any damn way. So we can still get the information. Still can get it without him. So, I mean, I recognize his position. I'm not going to say what his status is. I'm not going to technically say what he does, because that's my right-hand man. Like I got some other right-hand man who, when I process certain things that are needed, those are the guys who I go to, all right? Because they have access to the Bloomberg, all right? To have access to the Bloomberg, you gotta be kicking up at least $2,000 a month to keep a Bloomberg financial website going, all right? But I have my own way of accessing it besides the Bloomberg, all right? So when you do get the QSUP number, as I said before, you have to go to Fidelity website, Standard & Poor's, you gotta go to these brokers and say you wanna purchase a bond and you have the QSUP number. Please don't get wrecked. Don't let these guys know what it is. Don't be arguing on the phone with the broker, please. That's why I hate to get information for us to get reckless. Listen to what I'm saying. You get the QSUP number, you call the Fidelity broker. See, nobody knows this. Everybody would just run into the site and getting wrecked. But nobody knows to talk to the broker and give the QSUP number and say you want to purchase that bond. Because each QSUP number is connected to a bond, is associated to a bond, all right? And now he may ask you, how do you know about that? Because you're not supposed to know about your mortgage bond, student loan bond, credit card bond, auto loan bond. You're not supposed to know about that, all right? And this is the information I'm putting out there. Yes, brother, you have a question? He's gonna give you the mic. Thanks for this water out here. I'm getting dry up here. How dry I am.
So once you get the QSIP number and you purchase the bond,
Yes.
that puts you on the equity side. I presume.
There you go, brother. Please say that again.
Once you get the QSIP number and you purchase the bond, it puts you on the equity. You go from the debt side to the equity side.
There you go, brother. I'm gonna say what he just said. Once you get the QSUP number and you purchase the bond, that remove you from the debt side to the equity side. All right? They're playing games. One of my lectures down in Delaware, I did 3 lectures, April, May, and June. One of the lectures, I actually was showing you that you were actually the creditor. I actually drew a line and was breaking it down in detail that you were actually the creditor, but what they did is they cooking books. They're putting you on the debtor side as opposed to the creditor side. Because why would they need your creditor? Why would they need your credit and your credit rating and then call you a debtor? We never questioned that. Why would they need your credit or credit rating and then turn around and say, you're a debtor, now you owe this? Well, if you're the creditor, then how could you be owing anything? If you're the creditor and they need your credit report, that's your equity. And by the way, for those who don't know, each credit line, I don't care if it's Experience, Equifax, or TransUnion, did you know that each one of them is a trade line, that they're trading your credit? So usually when you do get a credit on a mortgage, student loan, a credit card, or auto loan, they're issuing you what you call is a trade line on your own credit. On your own credit. And they're going by your credit rating because once they get the bond, they take your bond and trade it on the market. So that's why the QSUP number is important, because as the brother said here, that then you transferring yourself from the debt side to the equity side. Because technically you're on the equity side, but they reversed you from the equity to the debt side. That's exactly what they did. Yes, brother. You got the mic?
This is kind of on subject,
Can I get some cold water? Yes, I'm listening, brother.
but when
'Cause I'm hot up here and I gotta cool down.
when we grew up as Christians, some people said what they call the Lord's Prayer for, like,
That's
forgive
in
us
there.
our debt. And
That's in there. Thank you, Morse Cole.
we forgive our debtors.
Yes,
But
that's
they-
correct.
Not all of them said that.
That's correct. Well, they changed up some of the wording.
But I'm understanding why they said that. They praying on us, praying to us.
That's
to stay
correct. That's
small.
correct. That's correct. What you're saying is correct, brother. Matter of fact,
That's wrong.
of course, well, let me tell you something, brother. Oh man, the pastors and the bishops and the evangelists, they're gonna wanna kill me. They'll go after me faster than the judges and the lawyers. I'm about to tell you. Oh, first of all, thank you, brother. Nehemiah, the 5th chapter. Nehemiah, the 5th chapter. One of the canonical books of law. 5th chapter, 3rd verse. God hates mortgages. So why is the pastors and the evangelists are getting mortgages on the masjid, on the synagogue, and on the church? You're not supposed to have a mortgage on your synagogue, on your masjid, or your church. You're not supposed to have that. Allah had the prophet Nehemiah in the 5th chapter. You need to read the whole 5th chapter, because he even talked about the things you're talking about, getting a loan from the king's treasury and charging you usury. All right? Under Islam and under Hebrew faith, there's no usury supposed to be charged. It's only under the Christian faith. The Christians should be following the same cultural idioms as Muslims and Hebrew Israelites, but they don't do that. They're the biggest usurists on this planet and the faith than any other faith. And you know what's sad? Muslims and Hebrew Israelites, or so-called Jews, are following the Christians. They heavy into usury. Because if you was to get your mortgage, you're supposed to get it without interest. You're supposed to get it without interest. You see what I'm saying? Whatever
Like a
you
loan for mom and dad.
That's right. Oh, in the New Testament, Isa, which Christians know as Jesus, Yahushua, from a Hebrew perspective in the name, he says in the New Testament, or in the gospel, I should say more proper, he says, do a king tax his son or a stranger? That's what he says. Do a king tax his son or a stranger? So I said, man, if a son tax his son or a stranger, you already know he ain't gonna tax his son. He's gonna tax a stranger. So why is the state who's calling you a citizen taxing you? You get what I'm saying? So that's what we need to recognize. So if the Muslims and the Hebrews and the Jews and the Christians was to stand up against this preposterous fraud that they perpetrate economically on the people, we can solve our problem economically. We can solve it. But they're going along with it. Muslims, Christians, and Jews are going along with usury. And we are suffering because the people won't stand up. But it's so sad that the homosexual community, they had a parade. And they standing up for their rights. But the religious people who's supposed to have integrity ain't standing up. So something is wrong with that picture. I'm only speaking because you're standing up, not because of your sexual preference. So I don't want y'all to be holding us to this and trying to shut us down on Facebook or whatever social media, because I know how you roll. So that's my disclaimer. I'm just only saying it because your support, like today, we went into a restaurant, and of course, we know who was in there, and they didn't want no cash, so we were subjugated to whatever they wanted there, so we know we can't support that. Not speaking against you, because you didn't want our cash, all right? So, but again, look what they do. So where's the Christians, the Muslims, and Jews doing what we should be doing? If Muslims, Christians, and Jews, the people of the book, according to the Quran, right, is supposed to come together and do what it's supposed to do, we can kill the banks. That's why I was really annoyed with Farrakhan. Love the brother. He has a very powerful image throughout the world, but he's not helping to liberate us financially. I have to say that. Farrakhan is not helping us to liberate us financially. He could have done that back in 1995. If he would have set up a credit union all over this country and have all the million men with their women and their children pull their monies out these banks and put it into our credit union, oh man, we would have made each one of those banks collapse. Wells Fargo, that go back to the slave trade. Barclays, all these banks go back to the slave trade. Financing slave trade. And if you know all this information, why are you not instituting financial institutions for ourselves? This is what I'm saying. So I'm not trying to put his feet or anybody's feet up under the fire, but we need to get it up and popping. Because what's going on today, they're crushing us financially. That's the reason why we have to awaken the mind to financial instruments. These are the financial instruments that you're using. We fall under one of these categories. Like, for instance, the electric bill. We have electric bill. But the electric bill, again, is being financed by investors. They put your name on that account. I know one particular mall out in New Jersey did a process that I've seen. He put it on YouTube. And got a bill credited to how much usage that he used. It was credited to him, $200 for that bill. And they wrote the brother a check because he went about it the right process. A lot of brothers and sisters are going about it the wrong way and they're causing problems. This is the only brother I know who got an electric bill credited to him, plus they wrote him a check. So if they wrote him a check and credited him the usage with the check, he had to have been doing the goddamn thing right. The only thing that I fault him on is that he should have got the QSUP number and see that he should have gotten the check for maybe $2 million as a 200. You get what I'm saying? That's the only thing I fault him on. Other than that, he did his due diligence. We got brothers and sisters out there doing the due diligence. Get the mic for the brother?
So in other words, that QSIP number put him in line. It was secured.
Well, he didn't go by a QSUP number. He went by another process, tax forms. He used certain tax forms with that utility company. Because a lot of us don't realize, and he's the first one I've seen made that process and was successful at it. I've been saying this, and I keep saying it again. It's an internal revenue issue. It's all internal revenue. Every single thing up here that you see here is all internal revenue. Last year, I freaked people out with the death certificate. Everybody told me the birth certificate. We forgot about the death certificate, and I showed you the agency where you're supposed to make the cash out on. That's on the, I did a PowerPoint presentation on it. And that blew people away. Because that's all you need to do is get the QSUP number on the serial number of the death certificate.
That's your QSIP number.
If it's your death certificate.
Okay, no, or
I hear what you're saying, but I had to make it clear.
Okay, all right.
I can't say it's yours, but what I'm saying is if his mom had passed, or dad had passed, or uncle, aunt had passed, you can create an estate for them, get the QSUP number, and begin to start to process that through the estate. All right, you got to do that through the estate. You can't claim that personally for yours because you don't want handcuffs on you.
Well, on that guy that did
For the utility bill,
the utility bill, if he'd have got his
QSUP number, he would have gotten much more.
Find out where that's been traded.
Yes,
And then
he would have gotten more.
He become the shareholder.
Yes.
He was a shareholder.
But each one of us is a shareholder.
Yeah, right.
That's correct.
So by him, but he had to.
He didn't apply the QSUP to it.
Right.
You know,
So he would have to write a letter. I saw one of your letters.
all right.
And.
Oh, yes. I know which one you're talking about.
So you addressed the CEO or the.
Yes,
And then told.
Yes.
Let them know that you're going to report them.
to FINRA.
Okay. So that's how you get that?
Yes, FINRA, yeah. Yeah, yeah, because what I did is I showed the trust certificates and those who were making the claim to that mortgage.
Yeah.
So when I put that letter together, it was notice of pecuniary interest is what it was called.
Right.
Notice of pecuniary interest, because exactly each one of us have pecuniary interest in this. But you gotta know where your interests lie.
And you can do that with each one of those?
That's correct,
Okay.
but that's your equity. This is what I'm saying. You have to awaken your mind to these financial instruments, all right? And what I'm saying here is that each one of these instruments here that you see on the board are all equity. But what the system have done under accounting fraud, that's why you hear me say economic gentrification. They have gentrified us with this. They put us in each one of these categories. And once they put us in these categories, then they create you as a debtor, stealing your equity. But as the brother has said, which is correct, that once you get the QSUP number and you get the bond on each one of these instruments, you're removing yourself from the debtor side to the equity side.
Right,
All right? Very important.
yeah,
This is a procedure that I'm giving.
yeah.
All right? But there's a process in the procedure to be done. So I'm not giving information for people to go out there and get wrecked, because a lot of that's going on.
Yeah.
Matter of fact, when I did my 3 lectures down in Delaware, there's folks around the country was stealing my intellectual property and they were selling it to other people. They were selling it to other people. You know, and that's what's going on. Instead of them working together so we can all eat, they decide to want to sell my intellectual property for $350 around the country. All right? And I'm aware of that. And there's other people stealing my equity, intellectual property and making money off me. They've been doing it for years. They don't think, I don't know who it is, and they're very close to me like a Judas Iscariot. You know what I'm saying? But I don't say nothing. You know why? Because I got too much up here to be dealing with breadcrumbs. You see what I'm saying? So I'm about the whole picture, not being partial to an individual who's stealing from me, all right? Because I got greater to give than what he's stealing from me. So he can get away with those crumbs, all right? What I got is far greater. I'm gonna be doing some serious stuff, brother. I'm talking about some serious stuff. I'm going through some changes. That's why maybe why Shaitan is at the door giving me hell, because some other stuff going on. My mom just recently passed. A lot of other stuff going on, you know what I'm saying? A lot of stuff going on, brother. You know, a lot of people don't know that Kemitu was catching hell. So I don't mean to neglect you or not get back to you. No, I'm just speaking in general, not you personally. But I've been there to try to help. But people got to recognize that if I'm not there, something is going on, because it's not me not to be there. All right, I don't just neglect people and leave them in the hole and have all this goddamn tons of information. I want you to have this because I know what we're dealing with out there. All right, thousands and thousands of millions of our people are subject to this. I don't know nobody in any faith that's not subject to what I'm talking about. All Muslims, Christians, and Jews dealing with mortgages. All Christian Muslims and Jews are dealing with the birth, death, marriages, mortgages, student loans, credit cards, auto loans, electric bills. And the supremacy, white supremacy, quote unquote, as they call it, is using this to control us through their economic platforms. All right? We are being traded and not realizing how we're being traded. This is, I had a class up in Temple University. I did a class. This is the new slave trade, y'all.
Yeah.
Do you hear me what I'm saying?
Yeah.
All the Afrocentric brothers and sisters out there.
Yeah.
But I used to study under Clark and Dr. Ben and Leonard Jeffries, and I can name all of them. And none of them knows this. This is the new slave trade, y'all. For all your Afrocentric brothers and sisters out there, this is the new slave trade going on right now. So the European, that old slave trade that they used to do, they threw that out the window. They got sophisticated. They can economically gentrify you through any one of these slave instruments, all right, and then sell you on the market without a struggle, without a fight.
Chain you up.
And then they got you voluntarily signing these documents. So this is the new slave trade right here, y'all.
Shackle you up.
So you know what's going on.
Yeah.
That's right, this is your new shackles.
Yeah.
Any questions?
So does that also include water bills as well?
Yeah.
All of it.
I should
All
have
of
just
it.
said utility bills.
Utility.
Yes, I should have said that, because each one of these instruments here are called transmitting utilities. Transmitting utility. Your birth certificate has you as a transmitting utility. They're using these as a remittance. And you know what they use as a remittance to these instruments? Your Social Security account. They're using you as a remitter. A lot of us is not even aware that you can go and check out what's on your Social Security account, like who's acting as a creditor. All right? We give up the number, but we don't know that we can call the Social Security and say we like to know who are the creditors who's making the claim against my Social Security account. Because if you notice, that's what they use against you.
Can you rescind that signature on that and make a claim to, let them know I rescind the signature and
On one instrument, beloved, because I read to you one day, I took you to a statute, trying to recall what it is. There's a lot on my mind, because they were specifically saying that you cannot rescind on residential housing. I don't know if you remember that.
Yeah, I remember.
There was a statute. I don't recall the statute at the moment. I have to, go to my mental Rolodex to pull that out, because I got other stuff on my mind too. But I showed you that the rescission is not on residential mortgages. That's a prejudice. I don't say I'm agreeing with it. I'm just saying that it's a prejudice. Why? Because they do give you limitations on rescission. They'll say, once you sign the mortgage or the note, let me say that in general. If you sign a note, right, you have 72 hours to rescind it, right? Or you got 1 year to rescind it, or you got 3 years to rescind it, all right? That's the most that we give you, all right? Because I've seen cases where people have put in a rescission, and the lawyers will come back and say that you're statutorily barred because you went over 3 years, or 1 year, or 72 hours. I've seen it. Yeah. Only reason why I know these is because I read a lot of cases. I got to see what these judges are ruling on what these lawyers are putting on based upon the statutes. So I got to read the case laws, I got to read the statutes, just like I was saying about the Rucker-Feldman earlier. Please, look up the Rucker-Feldman doctrine. Anybody who have got a judgment against them in state court, you must be aware of the Rucker-Feldman doctrine. Rucker-Feldman is R-O-O-K-E-R, Rucker-Feldman, and then hyphen Feldman, F-E-L-D, man, M-A-N. Rucker-Feldman doctrine. You should, anybody who's bringing a case into federal court, if you lost in state court, if it's a state court case that's been lost, that's one of the elements they're going to shoot you down on the Rucker-Feldman doctrine. So you cannot bring a case that's against you in state court, federal court, and say, that issue. I'm not saying you can't bring a case in federal court, but you got to stay away from those issues that you raised in state court or you didn't raise in state court. Because again, I'm reading these cases. I see what these lawyers are saying. I don't agree with these lawyers. Matter of fact, let me hit you in the head with something. That Rucker-Feldman case goes back to the Dred Scott case. That's how deep this is. And you say, what do you mean by that? Because these devils, let me tell you what's going on. These devils in the Dred Scott case, he actually won his case on the state level. He lost his case on the Supreme Court level under Roger B. Taney. You get me what I'm saying? Because who he lost it to, who he won the case against in the state level, that same individual ran to the Supreme Court before Roger B. Taney. And Roger B. Taney ruled against Dred Scott on the Supreme Court. The Supreme Court overstepped its bounds on the state court sovereign jurisdiction. And matter of fact, that state court was a free state. It wasn't a slave state like New York. Because Dred Scott came out of New York from a slave state to a free state. So the judge, Roger B. Taney, was a pro-Southern slave judge. That's who Roger B. Taney is. So now you can see that his decision-making is based upon politics. All right? It's based upon politics. But let me drop another jewel on you that most people don't know about. Roger B. Taney, even though that judge was wicked against Dred Scott, was the only judge that contested taxation on judges. In the United States Constitution, judges are supposed to be tax exempt for political reasons. They cannot make political decisions because of the fact of taxes. but they're not operating on tax exempt. So I came across some information where Judge Roger B. Taney wrote a letter to the Secretary of Treasurer about judges being tax exempt. And they ignored his letter. That was what you would call a tax protest letter. They ignored it. But he quoted the Constitution. And politically, the Secretary of State at the time of Roger B. Taney did not want to acknowledge what the Constitution says. They did not enforce the Constitution that judges are supposed to be taxed. It's in the Constitution to this day. And none of those judges would touch it. The only one I've seen touch that issue, well, no, there was another case way after Judge B. Taney. Oh, no, it was another issue. I forgot how many judges it was. They wanted to be paid in gold because they was being paid in legal tender. So these judges wanted to be paid in gold. That was another case. All right? So that, because they was trying to enforce constitutional issues. Roger B. Taney tried to do it, and several other judges, right? I think it was in the 1950s or somewhere around that time. All right, I think it was during the time of one of them cases. I think it was the Thompson Railroad case. Somewhere around that time, these judges wanted to get paid in gold. They didn't want to get paid on the legal tender. And that was an issue. All right? So if you see the politics of what goes on among them, what the hell you think they're going to happen to us? You see what I'm saying? So that's why we got to get our economic situation together. All right? And the best thing that ever happened to us is cryptocurrency. Cryptocurrency is the best thing that ever happened to us, which means we can have our own cryptocurrency and we can trade throughout the world with any other nation without being tied down to the legal tender. You see what I'm saying? Because you can see what's going on with Trump, with China. You can see what's going on in Mexico, putting all these embargoes on them, bringing up these tariffs while the produce is going up. You see what I'm saying? So if we have our own trade, do our own cryptocurrency, we wouldn't have to be subject to that. You see what I'm saying? Because they can't tax crypto. They're trying to do it, or they want you to report it. That's what the IRS is working on, trying to figure out how they can be able to tax cryptocurrency. You see what I'm saying? So it's very important to be aware of that. Yes, brother.
I don't want to go off too much, but how is it possible to lease your name?
Well, brother, what happens is that because we were not aware, right? It goes back to grade school. It goes back to grade school. Right? Grade school, this draconian word, right? And we already know this was going on. That's where it starts at, brother.
I got it. Okay.
It goes back to grade school. I hear you loud and clear, but I have to take you to the root cause that they put us up under this fraud. That's fraudulent conveyance of language. A noun, all right, our ancestors never did with nouns. All right, everything on the planet is moving. Everything on the planet vibrates. So where does noun come from? This whole concept came from the European because he couldn't see things moving the way we see. All right, so he wanted to entrap us to control us. All right, so he put this double negative. He's speaking about us in a sentence about double negatives, which is a part of our culture. So he speaks against it, but he ain't telling you that this now is a double negative, and he's using the double negative that we have in our culture against us as a weapon of warfare. We're not paying attention. You know, only thing we say is, oh, brother, you're using the double negative. That's, if you listen to African languages, they're all, you know what the double negative is all about? If you ask a teacher in English, a teacher and master in English, do you know what a double negative is all about? They couldn't tell you. It's about confirmation. You know how you say something and somebody said the same thing you said and didn't realize you said it? That's confirmation. So a double negative is confirmation. All African languages have that. But they want to kill that, but at the same time control it. So a now is nothing but a double negative, because no, it's not. Un means not, right? So they took two double negatives and put it together and call it what? That's what they told us. So then they turn around and put a person under double negative. All right? They put place under double negative. They put thing under double negative. So what are they actually telling you? You don't own anything. There's a book called Language of the Law. He gives you a beautiful breakdown of how the double negative was used. The noun was used. And when they use the noun as a negative. Today they use the noun, they say it means person, place, or thing. It doesn't mean any of these things. All right? And this is what they teach us in grade school. This is how they get to do this stuff, brother. All right? You know, anybody who knows me, they know I'm heavy into etymology. This is how I get wrecked. I know this stuff because I study language. So it don't make a difference if I'm studying finance, medical, whatever. I can go epistemology and etymology into whatever topic it is and tell you what's going on. I can tell you exactly what's going on. You know, and the worst thing that happens is when we start going into other languages, we always use English as a base. I said, no, you cannot take English and define Arabic, define Hebrew.
No way.
You cannot go into English, which is a modern language, and define ancient languages. It's impossible. But the people that's making that piece, so like earlier today, there was two brothers. One was from Igbo, because he said he's Nigerian. I said, brother, you're not Nigerian. I said, you're not Nigerian. Where do you get that from? The British colonized that whole area and call it Nigerian. So now you're saying you're a British colonist, a colony. That's what you're saying. But if you say you're Igbo, the British have no control over that. All right? So all them nations, they conglomerately put that together and call it one name. And they only did that because they wanted to deal with those different nations within that territory. That's what the British did. All right? In order to divide and conquer, they colonized. All right? And he recognized that. But then he was talking about black. I said, brother. And white. I said, brother. There's no African language has the name or term black in it. What you do is you say, oh, this, in Igbo, this word means black. No. I'm going to tell you why that's no. Because how old is that word in Igbo and how old is the word black in English? So Igbo goes back thousands of years and they recognize a thing and they got a name for it. It is what it is. You don't substitute it for something else because you're allowing the enemy to come in and infiltrate you. That's what's going on. And I told him about Ivan Ben Sertima when he went to college in England. And they wanted him to translate English law into Kenyan language. And he realized that there's words in Kenyan that's not in English. And when he realized what they was trying to do, he aborted the mission. He aborted the mission. So a lot of our people, Afrocentric, running around here, Shanetta, Shaka Atmos, all them folks, black power, this black. Ancient Africa did not say that. They didn't say that.
Or white or color period.
They didn't say that. Because we didn't use those words back then. So why are we subjugating ourselves to words that we didn't use 1,000 years or more? That's the question. And so now you're wondering why we're in this condition. It's the same thing that we using all this here. We using all these different instruments that we have no awakening of the mind of, and we are in the same condition. To me, this is colorable law right here. Birth certificate, death certificate, marriages, mortgage, student loans, credit cards, auto loans, electric bills, debit cards, and so forth are all colorable law. They're all operating on the color of law, which means it's an appearance. It's not even real. So they want to change your status from equity. They want to steal your equity and put you on the debt side. This is what this is about. And as the brother said earlier, which was correct, once you get the Q-sub number and you get the bond, you're removing yourself from the debt to the equity side. Because one of the things I was telling you, beloved brother over there, when it comes to acquired title, you have to show your equitable interest in the acquired title. You got to go back when you first had got it from the grantor. The mortgage company was not the grantor. Neither the assignments of mortgages is not the grantor. You got the mortgage, you got the land from the grantor. What you did was you mortgaged the land after you got it was granted to you as the grantee. You mortgaged it. You didn't have to, you could, what you could have, that's when the time you should have rescinded the mortgage. And they couldn't take the land from you because it was given to you by the grantor. A lot of us don't realize that. So we wound up allowing the bank to do what you call as reification, which is R-E-I-F-I-C-A-T-O-N, reification. They abstracted by registering your name on a deed of trust and stealing your property. There's two titles. They don't teach you this. I'm telling you. The mortgage brokers they ain't gonna come up in here, and real estate agents, they're not gonna come up here and tell you what I'm telling you. There's two titles. There's equitable title for the mortgagor, and there's legal title for the mortgagee. The mortgagee, you didn't know, you as being so-called, I don't even like to call you a mortgager. Technically, you are an investor under the guise of mortgager. And you didn't know that at the closing, you waived your legal title. You have equitable title, right? But if you have equitable title, why do you think that they're foreclosing on you? They're saying you owe this. But how could you owe this if you got equitable title? The reason why they're foreclosing on you, brother, because you don't have the legal title. So in your deed of trust, they got you down there either a tenant or an occupant. That's what they were saying. They say within 60 days or 90 days, depending on who's drafting up the contract, you have those amount of days to enter into the property to be subject as an occupant or a tenant. All right? So then the foreclosure becomes what you call a constructive eviction. All right? You have to do it is imperative. How come every state and commonwealth have a quiet title action? That's no accident. That is no accident. I have not known one commonwealth or state that does not have a quiet title statute. So when you sat down with me earlier today, and I'm reviewing your paperwork, brother, what did I do? Went to DC, quiet title statute. And you see what it was. That is supposed to be in your jurisdiction, jurisdictional statement. You're supposed to make a jurisdictional statement. If you're looking to get they're doing a quiet title action, you're supposed to make a jurisdictional statement, but you have to use the language within the statute as your statement. I'm gonna say it again. You have to use the language within your statute as your statement. You just can't just draft up something and think that that's your jurisdictional statement. You got to use the language within the statute because you're under what you call as adverse possession. All right, and then you got to look up the adverse possession statute. And each state has it, exactly. It ain't no accident. Because they battling each other. Only thing is we was not a part of the battle because we didn't know nothing about it. They were just shutting us down and taking our property. But when we start looking into it and say, oh man. And by the way, what we should have been doing is foreclosing on the mortgage ourselves. You can foreclose on the mortgage, on the bank. See, we always look at them foreclosing on us, but we don't look at us foreclosing on them. We can foreclose on their own mortgage against the bank. All right? That's another rescission. You know, is to foreclose on them. But if they're foreclosing on them, you have to counterclaim them with a quiet title. All right? Because they're using the title, the legal title, to foreclose on you. So your counterclaim is very appropriate. A motion to vacate the summons and complaint of foreclosure is very appropriate. That should be done equally as you doing a quiet title. All right? This is the things that we need to know and to do. And you ain't gonna get this from no goddamn lawyer. He's gonna be very limited of information he's gonna give you, and he's gonna charge you an arm and a leg for nothing.
How you spell it? Quiet.
Q-U-I-E-T, Q-U-I-E-T, and then title. And why you think they call it quiet title? You want to, as a matter of fact, how do you acquire your title? Let's look at this. How do you acquire your title? I already gave you the answer. The grantor, not the bank, not the mortgage company. That's where we're making the big mistake. Look at your deed or your deed from the grantor, and you're going to see the grantor's name and you're going to see your name. The bank is nowhere near on it, neither the mortgage company. So you acquired your title through the grantor.
Okay, you gotta go to the county or whatever.
Yes, to pull that from the time that the grantor transferred it to you as the grantee. All right? The mortgage, that's a whole new different reality. But I gotta get people's minds straight on what happened in the process. And a lot of us is missing that. So how you get jurisdiction back to your title, you've gotta go back to the time of the grantor with the deed. Oh my God, see how much I got, 924. All right? Is that clear? Noble brother, is that clear? Because you putting a complaint together. So I think that this is very crucial and vital to your complaint. In that jurisdiction area, that's called jurisdictional statement. You have to use the statutes to make the claim because you have proof. Just go back to your deed, going back whatever year, 2010 or whatever it is, and pull that. And the language on your deed with the statute should be in the jurisdictional statement. Show the court that you received this by the grantor, you the grantee, the block, lot, whatever how they put it, book page, you know how it go. You see what I'm saying? That's what you got to lay down, brother, because you have to show equitable interest. You have to show the equity side. When the bank go after you to foreclose, they're showing you the debt side. They're putting you on the debtor side. That's what's going on. They're flipping it, you know, from day one. Because from day one, you were the creditor. You had the equity. Once the grantor transferred 100% of that property to you, that was your 100% equity. Then what happened is you mortgaged that off. That was secondary. You see what I'm saying? Yes, brother. Can you give me the mic?
Yes.
Behind you? Yeah, thank you.
Who is the grantor?
The one who you got the property from. The person who probably owned the property. It wasn't the bank. It wasn't a mortgage company.
Understood.
You get what I'm saying?
Yeah.
So whoever owned the property prior to you, and you say, oh, I like this property, I want to buy it, and you of course, you say, listen, how much you want to sell your property for? He tells you what it is. You said, deal. You see what I'm saying? So he writes the deed or transfer the deed over to you, and it's recorded at the clerk's office. If you look at that deed, brother, the bank is not on that. The bank or the mortgage company is not on that deed. It's between you and the grantor. What happens is you turn around and pledge your deed to the bank or the mortgage company, and they in turn gave you a mortgage. So what I'm trying to do is get you to see what happened first. See, you know what happens? What we think would happen? Oh, I got the mortgage. I mean, I got the property by the way of a mortgage. That's how they got you thinking.
Right.
I'm aware of that.
Right.
You see what I'm saying?
Right.
All of us in the millions would think that way. But what I'm trying to do is get you out of that thinking. You get what I'm saying? You did not get the property through a mortgage. That is not true. If you think I'm lying to you, go pull that damn deed and look at it, and you will not see that bank or that mortgage on that deed. It was between you and the grantor. What you did was mortgage the deed off to the bank. That's the secondary thing we did. Yes.
So
I'll be coming.
once the grantor transferred the deed over to you, basically the transaction was really done.
Thank you, brother. And
You
it says,
didn't need a
and
mortgage.
it says consideration of $1, $10. That's correct. You didn't need the mortgage. You hit it right on the head, brother. He needs the mic. You hit it right on the head. That's exactly. This is what I'm trying to get people to see. That's the part that they got us on the blind side.
Right.
All right. We don't see that side. Yes.
So,
That's correct.
so the grantor is actually on
The deed.
on the deed of trust.
Yes. Not the deed of, all right. When you say the deed of trust, the deed of trust is separate from the deed now.
Okay,
So we got to be careful.
okay.
I hear what you're saying. The deed of trust, see, in Maryland, they got what they call as the deed of trust. They look at that as mortgaging the property off.
Okay.
This is what they say. On the deed of trust, they say that you, the grantor, on that deed of trust, when you look at it,
Okay.
then there's a trustee who is the robo-signer.
Okay.
And then the bank or the mortgage company is the beneficiary. Go look at it.
I saw it.
And when you see that, you say, oh, wow. So how in the hell you give them the money, or they're giving you the money to buy the property, but they're the beneficiaries? How that happen? We don't question that. You get what I'm saying? So if you look at that deed of trust, I know how it's written up, brother. There's 3 parts to that.
Yeah.
That's the part you got to look at.
Yeah.
But you know who you go after? the trustee.
Okay, now, do I file a quiet title to the trustee also?
I'm in the lecture, call you back.
That-
Say it again?
Should I send a quiet title to the trustee?
Well, what you could do, you mean the trustee?
Yeah,
What you could do, you listen to my brother with the complaint? You can make,
Hello, Moto.
I'm in the lecture. You can make the trustee a defendant,
okay,
all right? Because he was the one who took your deed into trust. That's why they call it deed of trust.
okay.
And claiming that he's the trustee. Excuse me, you didn't even met.
Never
I'm
met-
aware.
Exactly. And we don't even hardly know his name, even though it's on there. But what we didn't do, we didn't call him up. You can put his name. Matter of fact, let me drop some jewels on you so you'll know what's going on. For the deed of trust, because each state got something different going on, and I've studied all of it.
Okay.
So I can answer the question to all of it. If you got a deed of trust, what you're supposed to do, and you're taking notes, what you're supposed to do is go down to that goddamn clerk's office. They have what you call a substitute trustee. And they got appointment of substitute trustee. And usually what happens is that the one who's the trustee on your deed of trust, he's supposed to be listed within the clerk's office. All right? That's what they do. Or if they don't list him, they would transfer your deed of trust over to the substitute trustee in order to foreclose on you. That's the process that they do.
Okay, because I didn't find the substitute trustee, he was not on,
He should be there on record.
okay.
All right, that's why I keep telling people, I gotta see your paperwork. Yes, true. He knows that it's land records. Did you go to?
Yeah.
Yes. Sometimes they don't be there. Sometimes they'll be acting clandestine. Most of the time they are there. That I know for a fact. I do too much research in this area not to know that in other areas of other states or Commonwealth that deals with deed of trust because they deal with the same format. So that's why I'm so familiar with it. All right, because Maryland is not the only state that deals with a deed of trust.
Okay, my question to you, that quiet
Title.
goes to the trustee and also.
No. Let me say it again clear. You're gonna have defendants in the quiet title. You're suing for your title back.
Okay,
The trustee of the deed of trust is gonna be a defendant. He has to be served as a defendant.
okay,
You follow me? He's gonna be listed as a defendant on your quiet title action.
okay,
He's one of the defendants.
okay,
The lender who's claiming to be the beneficiary is also one of the defendants.
okay,
You see what I'm saying? And you are the plaintiff.
okay.
All right? Now, if it's been transferred to anyone else, they equally have to be a defendant. Because sometimes they do an assignment of mortgage to transfer it from one lender or creditor to the next one. So they equally have to be a defendant.
Now, the
This is the stuff that I put together,
okay,
you know,
the service provider
can equally be a defendant too.
Okay, okay,
All right? Because he's servicing the fraud.
right,
Because he could be, you know what I'm saying, and the servicer falls under 12 USC Section 2601 at all, meaning and other statutes. 12 deals with the banking. 12 USC Section 2601 at all. The service is all up in there. Usually when I do a qualified written request, when I do one, it's not, you can go online and pull up all them templates. Ain't none of them touches what I put together.
okay,
Because when I do a qualified written request, I make sure that I ask for the deed of the trust. Because they transfer your deed of trust into another trust.
now,
You get what I'm saying?
Yeah.
They would transfer your deed of trust into another trust.
okay,
All right? And usually I ask for the name of the trust. And they would give that up. I also ask for escrow history. All right? Because one thing that people don't know about, that I'm aware of, is that they don't report that on your credit report. A lot of people don't know that. They don't report, you know, whatever payments you're making, they don't report that. They hold that back. I forgot what they call that, but they hold that back.
now, what I noticed on the qualified written request, I put in a lot of that, the stuff that you're talking about.
All right.
Maybe not exactly what you got.
All right.
But they only give you certain things, and they said, if they don't answer all those questions, because they'll make some excuse that they.
Well, some things they may not can answer now, so I don't know what it is. See, people tell me these things and I hear you, but I don't know what you put together. Once I see it, because some things, they may not can give you that. You get me?
Yeah.
But some things they gotta give it to you. But one thing I do know, they are subject under 60 days to give you what you request. That's providing what's related to the contract, everything that's related to the contract. Because some people ask for things that's not related. You know what I'm saying? So you can't ask things but not related and say, oh, they didn't answer. You have to know what relates, the items that relate to your loan and what items don't relate to your loan. Like for instance, you have to ask for assignment of note. Most people don't know about that. You know about assignment of mortgage, but you don't know about assignment of note. You don't know about the receipt, because at the closing, if you make the because see the mortgage note, listen to me carefully, y'all, for out there who's paying attention. For when you went to the closing, the note was the payment. All right, not just your signature, because people say your signature. All right, signature can be on anything. Doesn't mean that it's payment. Once your note hits that signature, and you give that to the bank, that is considered to be payment. I can prove to you that the mortgage note was payment of your mortgage in full. I can prove that to you. I did research and find that out on my own. When you go down to the taxation department for the land records, there's a 1% mortgage tax.
Yeah, that's what the lawyer told me.
Do you hear what I'm saying? Thank you, brother. That's how you know I'm doing my research. There's a 1% mortgage tax.
The lawyer told me.
So listen to what I'm gonna give you, a comparison. You go to the store and you get an item and you pay for that item, they're gonna tax you for the purchase of that item, correct? So how in the hell that you pay for that item in full and they taxed you, but you still keep paying for the item? Do you get what I'm saying? You don't still keep paying, you pay the tax. What? Let me give you another one. Let me hit you with another one that's gonna blow your mind.
That's a big jewel there.
Big jewel. I got another one that's gonna bring it home even better. I had a Japanese client for child support. We did a chapter 7. One thing they say is, oh, you cannot bankrupt child support. That's not true. I did it. The arrears. Anything in the future, you can't do it. But anything in the arrears, you can. They're not gonna tell you that. So they'll throw you off. So he had $60,000 worth of child support in the arrears. I bankrupt all of that. Guess what happened after I bankrupt? The taxation and finance department sent him down a tax warrant for 12 grand, which is the portion of that tax of that $60,000 child support. Do you hear me what I'm saying? They sent a $12,000 tax warrant. What I did is took the same discharge that I was talking about earlier, put a little cover letter with the discharge, sent it to the taxation and finance department up in Albany, New York, and guess what? They removed the tax warrant at the Kings County clerk. I gotta go back and get a copy. That was about 10 years ago. So once we show that it was discharged, that means the tax was equally discharged. But then they'll tell you, oh, you can't discharge tax, or you can't discharge child support. That's crap. I did it.
Yeah, they gonna lie to you.
You see what I'm saying? Yes, brother. You got more questions? Because he got a question. Yeah, you see what I'm saying? But the only reason why they can lie to you, is because we don't know. So this is the reason why our topic is awakening the mind to these financial instruments. Because we don't know. Yes, brother.
I'm seeing that this is trade.
Oh, yes, the court's a trading post.
No, I'm talking about what we're doing is trade, like we've always done.
You have to explain that.
All right.
Because you're speaking ambiguous. So you have to define what you mean by trade.
All right, you got his child support discharged.
Yes.
They hit him with a $12,000
Tax warrant.
What you did was a thing or a service, and it was like money, whatever you did.
No. What happened was I removed the obligation because remember, this is the term that they use, brother. This is the biggest term that they come after you. I don't care if it's state or federal. That's the biggest word, federal or state, is a tax liability. When they say liability, you know what they're talking about? Obligation. So the discharge, as I said earlier, remove you from the obligation. So when I did that for the child support, for the arrears, they came back and thought they were slick and hit them with a $12,000 tax warrant. So when they did that, that's when I got the discharge with a cover letter, sent it up to them, and then they removed the $12,000 warrant, tax warrant. It's on file at Kings County Clerk's Office. I gotta go over there real quick and get that. They may destroy that. Because I like to show people proof. When the people see that, they're gonna like, oh my, even lawyers is like flabbergasted, like, damn. And these guys wanna hire me. I don't wanna work for no damn law firm. All right? No damn law firm, because they're all fiduciaries of the state.
Thank
You got it.
So what you did was use a tool,
I don't think it's on.
what
Yeah, there
what
you
you
go.
did was use a tool back on them.
Noble Drew Ali made it clear to me. Drew Ali said, give the European back his Christianity.
Right.
That's what I did. But we have to first know his Christianity in order to give it back. You get what I'm saying? If we don't study his Christianity, then how are we going to give it back to what we, you get what I'm saying? So Noble Drew Ali said we got to give European back his Christianity. And that's what I did. You know what I'm saying?
Like you stated earlier,
Exactly.
you gotta attack them too. Attack them. You have to attack them back. When they attack you.
Yeah, but I attacked them based upon the statutes,
Right.
their statutory laws. They're subject to those laws too,
Right.
all right? Because they uphold those oaths to those laws. So I give them laws back to them. So, but in order for me to give it back, I gotta know it. I just can't just draft up any old thing and expect them to follow it. No, they got a protocol that they go by.
Thank you.
You follow me what I'm saying? They got a protocol. All right? We clear, brother? Because I want you to be successful in your quiet title. In your jurisdictional statement, you have to use the DC statute. Use the language. Don't just say statute number 16 dash so and so and so. No. Look at the language and then take the language from the statute and put it in your jurisdictional statement. And then you must state your description of your property, block, lot, page, Libra, you know, the works. That's all, that's you what you're quoting or stating there, that's your equity. All right? And when you do a quiet title, let me say this, you don't sue for money. A lot of people don't know that. There's no money, you know that, right? There's no, all right, I'm glad you said that. A lot of people don't know that you don't sue for money with a quiet title. Any other action, yes, not with a quiet title. Only thing you're doing is to get the title back. All right, when you get the title back, you're getting the equity back. You see what I'm saying? That's in the title. But if they want to play games, brother, because I know that the judges are corrupt, that's why I was given 28 USC Section 454, because the magistrate, the judge, and the justice are all lawyers, and I said before, what you do is take their name, go to the bar of that state or commonwealth, or wherever you domicile at, put that judge's name in there, in the bar, and you will see that he's a lawyer. That automatically disqualify him under 28 USC Section 455, Section 4, because then he's operating with fiduciary interests. All right, because why? He has a bar card, he's paying dues. So it's the bar association that's coming up against you. Now, Isa, which in English they say Jesus or Yahweh Shai in Hebrew, spoke against those lawyers in Luke chapter 11. All right, Luke chapter 11, he spoke against those lawyers. When they see Isa was screaming on them religious leaders, the chief priests, the Pharisees, the Sadducees, and the lawyers stood back and was watching when he was chewing them out and got the audacity to ask Isa, do you reproach us too, master? This is what the lawyers were saying, and he chewed them out, talking about the burdens that you put on people, you wouldn't even touch it with one finger. All right, this is in Luke chapter 11, verse 45. When you go to 52 goes into the bar association, because he says those who were going forth, you hinder. You yourself don't want to go, that's the bar. Yes, 52 verse 52 goes into that, talks about the bar association.
No.
Yes,
What about the magistrate that is acting as a judge?
What-
He's not a lawyer.
yes, he is. Because according to, if you go into their statute, in order for him to be a magistrate, he have to have a certain amount of time with the courts. He have to have a certain amount of time. I have to look what it is for here. I know in New York, in order for him to be a magistrate, he have to be a lawyer. He have to be in practice with the courts as a lawyer. We know how they start off as a hearing officer. That's what they start off as. All right? And they move from a hearing officer to a magistrate. But he have to be a hearing officer for at least 5 years before he can become a magistrate. So it's a due process. So that's in New York. I don't know what's going on over here, because each state got their own process. All right? But the point is, what I'm saying is the magistrate, remember now, Noble, go to section 454, it's telling you that if the magistrate, if the justice or the judge cannot be practicing law from the bench. And how you know that there are lawyers practicing law from the bench is because you take their name and go to the bar association and put it in, it's gonna come up saying, they went to this particular college at this year, and when they was admitted to the bar. It goes into that. You know, that's why I love PowerPoint presentation. Because I go into a PowerPoint presentation and be knocking your shoes off your feet and showing you all kind of crazy stuff that I be running into when I be studying like a madman.
So if he's on the bench, if the judge is on the bench, he can't, and he can't still hold his,
Office as a judge. He's supposed to.
He's in violation.
He's supposed to renounce his bar card, which they don't do.
Okay.
Which they don't do. You see what I'm saying? And a lot of, hundreds and thousands of these judges across the country is doing that, brother. The problem is not because they're doing it, it's because nobody's challenging them. Nobody's going up against them. You see what I'm saying? That's the problem. It's the problem. The problem is like, again, the quote-unquote LGBT community is all standing up for what they concern in their sexual preferences. I can't say rights, because that's not a right. All right? Whatever their sexual preference is, that's what they're standing up for. All right? I'm saying it's disturbing to me that the people who doesn't support that is not standing up.
Yeah, stand there, right.
They're allowing that to go on.
Yeah, you have to speak on it. And
So,
bring action to it.
thank you.
Yeah.
You know what I'm saying? So the religious order is allowing that to happen. And then you're gonna let that movement infiltrate politics, infiltrate television or media, infiltrate the religious movement, all right? Mostly, well technically, I have to really say this. You ain't gonna find them with the Hebrew Israelites and the Muslims. You really find them with the Christians. Because all them Christian church seems to condone that, if you get what I'm saying.
Right.
But Hebrew Israelites and Jews and Muslims, you don't see them supporting that. You know? We don't see them supporting that. All right, it's about 10 to 10, and I know we stop at 10, right?
Yeah.
All right. You better get out the questions. Yes, brother. Better get out the questions, because time is getting of the essence.
I'm not sure if I heard, but how do you get land back?
Quiet
All
title.
family,
Quiet title. I mean, how long was it?
long time.
I don't know what that means. Because the English language is ambiguous. You got to define what you mean when it's a long time.
Like great,
10 years, 20 years,
No.
30 years, 40 years?
maybe
Listen-
40 or 50.
All right, listen to this. Thank you for that question. Listen to this, y'all. For those who have lost property, listen to me carefully. Lost property 5 years ago, 2 years ago, 10 years ago, 20 years ago, you still have a claim to your equity. You have to get the title to that property, right? So we can get the QSUP number on the serial numbers on that title. And then
Taken
you
by
can
the-
make the claim, yes.
Taken by the federal government from my direct family.
What you mean by the federal government?
They brought eminent domain.
Brother, you still got a claim. Because usually in eminent domain, which I'm aware of, when those federal governments do take land from people, they usually give you compensation according to the Fifth
Yes,
Amendment.
it was a conversation,
Yes.
But-
Yes, they would do that.
but learning about being a Moor, it's
Yeah, I hear what you're saying, but you know what the problem is, brother? It kind of reminds me of the Indians, if you get what I'm saying. That if you traded with them, then how can you get it back? You know what I'm saying? But I'm not saying that it's a complete loss, don't get me wrong. But I'm saying that's why I know what you're talking about when you're talking about eminent domain, because I do know the federal government have to pay you by law for that property. They just can't take it without paying you. So if you receive the compensation, that's it. You get what I'm saying? It kind of remind me of
Is that it?
I don't think you get what I'm saying. When you made the trade in the eminent domain, that was it because you received the compensation. I'm not saying that's not all the money that you have according to your equity. You have to go back and look and what's under the registry, get the CUSUP number and see what the bond is, and you still got the claim because you can say that the compensation was not just compensation. Just compensation is not the same as compensation. All right? So that's what I'm saying. It's not it. It all depends. All right? But because you concealed the deal by the trade, you kind of close off the deal. But I'm not saying that that's it. You can get the serial number from the title on that land going back to the book registry and get the CUSUP number to see where's the bond at and make the claim on the bond.
Thank you.
That's what I'm saying. You know? Yes, brother.
So, is there a percentage for the cost of the bond to the note?
Oh.
Just so you know, like, when you talk about purchasing the bond,
Thank you.
it sounds like a lot of money.
No, it's not, because the brother who I found his mortgage bond, all right, and he was shook. And he said, well, how much is the bond? I said, well, the bond was $1,000. He said, oh man, I'm gonna buy up a bunch of bonds. I said, you don't need a bond. You only need one. That's all. So why are you gonna buy a $5,000 worth of bond? Well, what bond can do, what one bond can do if you had 5 bonds. So it don't make sense to buy 5 bonds, as an example, what one bond can do.
So once you make that $1,000 purchase of the
Yes,
bond, like that
yes.
scenario you
And that's just the
mentioned.
scenario in his case.
In his- in
Every
just that
bond
scenario.
may cost
It is
something
different,
different,
right,
maybe
yeah.
$500, maybe a little bit more, you know, but in this case it was 1,000.
So then what happens to the note after the purchase?
Oh,
Does
you
it,
gotta
I don't wanna
think-
use discharge, but
No, see, what happens is this. When you get the bond, you become the fiduciary note holder. Because they have the term note holder or certificate holder. All right? So you have the bond. So when you get the bond, that's it. Because the bond releases you from, as you said before.
the bond is connected to.
Yeah, exactly, to the debt. And now, when you get the bond, you get your equity, that's right.
Done at that point.
That's right, you're done at that, yeah, exactly. So there's no discharge involved.
Right.
And there's no obligation involved.
Right.
And there's no tax liability involved.
Right.
You see what I'm saying?
What's going on with that, treasury bond? What was it, 25,000, 50,000 you was talking about? 50,000, right? And
Oh, yes, what you're talking about, Ali, which got my man, I'm intrigued, Dr. Baruch. You're talking about, we're talking about annuities. They got annuity bonds. And what I've been trying to do is keep our people economically sound, because we really shouldn't be out here working for money. If you're working for money, technically you are what you call as an indentured servant.
Yeah.
All right, so you shouldn't be if you work, it's because that's just your trade. That's just your skill. You want to do that. You want to be, contribute to humanity or society. That's different. But if you got to run there because you're forced to work for money, that's a problem. But if you have a skill or career or trade, that's just your obligation that you're doing to society. But to work for money, what they did is they incorporated that into your career. So now your career is prejudiced with money. So if you don't go home with your career, you can't get no money. It shouldn't be that way. So what I show people is that if you have, hypothetically speaking, 50,000, you go get what you call as a municipal bond, right? And you have to find out from within that municipality what percentage they're gonna give you, because those municipal bonds are tax-free. What you're doing is actually loaning the municipal government a loan, a money, all right? So that's what makes it tax-free, because all those municipalities are non-for-profit. So they can issue up bonds as non-for-profit, tax-free. And you can earn the interest on those bonds. So if you're earning, say, 1%, which will come up to about $1,000 weekly to $4,000 monthly. So we're talking about annuity bonds. We need to purchase a bunch of annuity bonds, because then you let the bonds work for you instead of you working for the bonds. And this is what I'm saying about these things here. Because these bonds here are really working for you on the equity side, but they got you on the debt side working for these same instruments. All right, so this is what we're talking about, awaken your mind to these financial instruments. Yes, brother, you got the mic? Any questions from Facebook, Ali? Because I know that you just had one.
Does this have anything to do with the Treasury Direct account? Or is that
No. The Treasury Direct account, listen to this, because a lot of folks is talking about that, and they're not talking about it in its proper context. So let me explain what you're talking about.
Explain it.
I don't recall the form. It's a form that you have to fill out. Anybody can open up a Treasury Direct account. What happens is that when you open up a Treasury Direct account, you have to have what you call a securities attorney. Most people don't know that. I be hearing all kind of stuff going, you know what I'm saying? They don't know. I mean, and that's 10, 15 years ago stuff that you asking me. There's an application that you fill out. Q-subs is involved. I don't remember the name of the application. If I get it, I'll tell you. Because like I said, there's a lot going on. Sometimes I gotta go to my mental Rolodex to see where it's at. They got Q-sub numbers. They're gonna ask you the amount, and then the securities attorney will do the transactions for those securities to go into that Treasury Direct account that you're talking about. You need a securities attorney. Let me hit you with something that you need to be aware of. When I was dropping this information on a particular Moore, he went into the bank and tried the bank for the information that I'm talking about. The vice president of the bank scared the hell out of him, because when he went into the bank, he was talking about opening up a Q-sub account. Because a Treasury Direct account, you didn't know it as a Q-sub account. You see what I'm saying? That's what that is. So, you talk better, huh? When he went in there, he was asking some of the managers, they didn't know. So the manager went in the back and talked to the vice president of that branch. And when it was brought to that vice president's attention that this Moore, which they didn't know was a Moore, was just asking about Q-sub account, he ran outside and greeted the Moore to tell the Moore to come in to his office. He told the Moore specifically, if you come to the bank about this account, just come directly to his office. Don't talk to no manager or anything. Because they don't know. They're not trained in that. So the Moore bear witness on what I'm talking about. But he was foolish for what he did. So when the vice president sat him down, all right, about these Q-sub accounts, which is securities, the first thing he asked the Moore, he said, who's your securities attorney? As soon as he said that, the Moore could answer the question. Because whoever hear about securities attorneys. Because in order for you to process that, brother, you have to have a securities attorney, because they're the ones who's gonna have to transact for you, because they're licensed to do that, because those are nothing but bonds and you have to be licensed broker. So that's why even when you get your Q-sub number and you get on the phone and you talk to a broker in Fidelity, again, it's a broker who's licensed to transact on your behalf. The only thing you, give me a minute, no, the only thing you have to do is have a Fidelity account open. So that way when he transact, he can transfer the bond into your account. That's the only thing you have to, but you cannot do that on your own. It have to be somebody licensed. You see what I'm saying? So that's why he asked the Moore, who's your securities attorney? The Moore, he did not respond to that. So I said, Moore, why are you going to the bank and do that? Why would you do that? You know what I'm saying? Pardon me, beloved. You were saying something as I was trying to give information. What was you saying?
Use the mic.
Use the mic,
So
brother.
the securities attorney is the intermediary between you and the
The securities that he's purchasing or transacting for you to put into the account. Yes, he's the broker. Thank you, beloved. All right. Now, it's interesting that she said that. Listen to this real quick. Interesting she said that. That's 1099B. 1099B is broker or barter exchange. What I wanted to show you earlier, real quick, that you need to know, because she brought it back to my attention. You need to be aware of this. Because I don't hear too many people talk about 1099B. They talk about the 1099A, they talk about the 1099C, but they don't talk about 1099B. Check this out. Publication 334. Check this out. Publication 334. All right? And this is what you need to know. It's publication 334. A lot of people don't know about this. And what happens is this. You go to page 24. This got to go back to notes. The mortgage has a note, student loan has a note, credit card has a note, auto loan has a note. That's why when you get a securitization audit, the first thing they want to ask you, do you got the note? Because he needs the note, all right, in order to be able to find the transaction. But when you go to page 24, real quick, I'm going to read something to you. You need to see this, page 24. Come here, Ollie. This is publication 334. You see what it says here, Ollie? Want to read that? What it says?
Promissory note?
Yeah. Promissory note.
It says report promissory notes.
Speak up a little loud, no.
No, I can't
I'm sorry.
do two things at the same time.
I got you.
Report promissory notes and other evidences of debt issued to you in a sale or exchange of property that is stock and trade or held primarily for sale to customers or Schedule C or CEZ.
Exactly. But the main thing is they're saying report what? Promissory notes.
Right.
Who does that? Who reports promissory notes? And that's under 1099B. And look for the instructions. I always tell people go for the instructions because the instructions tell you what's going on. So is the mortgage company reporting the promissory note in reference to this tax liability? Is the student loan promissory note being reported? So this is why you can hit them with a 3949A, because they're making profits off your promissory note, which is the equity, but they're putting you on the debtor side. But you can remove yourself and make a claim for that note on the equity side. A lot of people don't know that. It's publication 334, page 24.
Hey, look here. Let's give it up for the brother Kemitu you.
Oh, yeah.
Because he's giving up information. I mean, when you go back, or anybody on Facebook or social media, actually look at this, it's deep. And so sometimes we follow certain people, you know what I mean, and we're into certain people, but you gotta listen to, man, and look at all the codes and statutes, man, he giving, man. This stuff, man, can punish this system, but we gotta do it.
That's right.
We gotta do it collectively.
That's right.
We gotta come together collectively, and it can happen, man. But we gotta get out of here. Peace and love to everybody. See y'all
Yes.
next
And
time.
don't forget the Cash App.
Yeah.
Oh yeah, the Cash App. The Cash App. Cash App, $Ali Productions. Come on, y'all donate. All we want is $1. That's it, man.
That's all.
Come on, we can do this.
That's all.
Cash App, $Ali Productions. Peace.
Okay, family.
Thank
I
you,
just
brother.
ask that you subscribe.
brother.
Thank you so much for tuning in.
All right,
Subscribe
brother.
to
We're gonna talk. You got my number,
the
right?
channel because we
Excellent.
are always
All right.
bringing you
I don't wanna burden you now.
informative
all right, good talk.
content, as you can see. It's a lot more to come. It's a lot more to come. So make sure you hit that subscribe button and let all your friends know. And tune into our program tomorrow. It's going to be very interesting. The Power Hour. We're going to be talking about are we sleeping with the enemy?
Oh, yeah.
Yeah, so that's our discussion tomorrow.
Yeah.
It's
That-
gonna be,
we
you know,
just
the
scratched the
energy, the
surface.
male, the
Because
feminine,
just
and
giving
masculine
people
energy,
general
both are gonna
information
be in the
what's going on,
room.
but the bond side,
And we're gonna be
that's-
talking
that's
about
another
how
lecture
this
by itself,
society
'cause
affects
I would have to do
our
a PowerPoint presentation
personal,
on that bond
our
side.
relationships,
Because
our
what
one-on-one
happens is that
relationships. How is
there's a
society
securitization audit
affecting our
that goes on
relationships?
with these bonds.
All right, take care. And
what
that's
happens is
tomorrow,
they got
2
the
p.m.
Bloomberg.
Eastern Standard Time.
So a
Take care,
PowerPoint
family.
presentation
Peace.
would be the appropriate